This video is part of a series intended to help citizens, members of the media, public officials, or anyone acting on their behalf to better understand Florida's exceedingly broad Public Records Act. These videos may be used by anyone and may be freely distributed without charge. I am not an attorney. I am not qualified, nor am I authorized to give legal advice to the public, so I don't. Any information provided by me in person, on video, or through fogwatch.org is readily available from the Florida First Amendment Foundation and the Florida Attorney General's Office of Open Government, as well as many other sources online.
I'm going back south, hit a palm tree shake at night.
In 1979, Florida Power & Light sought access to records within the custody of the City of New Smyrna Beach Utility Commission. New Smyrna Beach demurred and claimed that its attorney would first have to review the records and perhaps remove privileged or confidential material. The Florida Supreme Court held that public records are made confidential by statutory law, and not those documents which are confidential or privileged only as a result of the judicially created privileges of attorney-client and work product. If the common law privileges are to be included as exemptions, it is up to the legislature and not this court to amend the statute. With respect to New Smyrna's other claims, the court held that the portion of the statute relied upon by New Smyrna provides that examination of public records shall be permitted at reasonable times, under reasonable conditions, and under supervision by the custodian of the records or his designee. It is clear to us that this statutory phrase refers not to conditions which must be fulfilled before review is permitted, but to reasonable regulations that would permit the custodian of the records to protect them from alteration, damage, or destruction, and also to ensure that the person reviewing the records is not subjected to physical constraints designed to preclude review. In 1980, the News Press Publishing Company filed suit against John Gadd, CEO of the Lee Memorial Hospital. Gadd refused to provide access to records sought by the newspaper. Gadd argued that releasing the records would result in financial harm to the hospital, and that the records were being sought for malicious purposes rather than any useful public purpose. The second DCA held that absent any statutory exemption, a court is not free to consider public policy questions regarding the relative significance of the public's interest in disclosure and the damage to an individual or institution resulting from such disclosure. The court went further, finding that the hospital's defense alleging malicious motives for seeking the documents is likewise irrelevant. The Public Records Act does not direct itself to the motivation of the person who seeks the records. In 1980, the Jacksonville Electric Authority, JEA, a publicly owned and operated utility, hired a private consulting firm to assist in the evaluation of prospective JEA executives. When a local television executive made a public records request for the written notes created by the firm in connection with a contract with JEA, the consulting firm refused. In its ruling in favor of access, the Florida Supreme Court expansively defined the term public record to be any material prepared in connection with official agency business, which is intended to perpetuate, communicate, or formalize knowledge. The court held that such materials, even in the custody of a private, non-governmental entity, are subject to disclosure when that private entity is acting on behalf of a public agency. In 1981, a newspaper reporter named Blankenship sought access to records in a criminal prosecution. Those records had been disclosed by the state attorney to the defendant. The state attorney, however, refused to provide Blankenship with access to the records. The fourth DCA held that once records are released to a criminal defendant, they are no longer criminal investigative information and are subject to disclosure. In 1982, in a grotesque attempt to circumvent the Public Records Act, Ronald J. Tober, director of the Metropolitan Dade County Transit Agency, transferred physical custody of certain records to the county attorney. Claimants in a lawsuit against the agency had sought access to those records. The third DCA held that a public official might not avoid compliance with the Public Records Act by simply transferring the documents to another person or location. In 1984, Dan Forsberg and Walter Freeman, two tenants in a public housing facility operated by the Miami Beach Housing Authority, filed suit seeking to prevent the Housing Authority from allowing public access to records provided by the plaintiffs to the Housing Authority. The Florida Supreme Court held that the Florida Constitution does not provide for a right of privacy in public records, and that barring a legislatively created exemption, such records are subject to disclosure.
Going back south, hear the palm trees shake at night. I'm going back south, hear the palm trees shake at night. My Florida woman, she knows how to love me so right.